Morning, everyone, and thank you so much for dialing into our webinar session this morning. We have still got quite a lot of people that are joining as and when, so I'll keep this introduction going whilst we still have a few more people dialing in. My name's Misha Bristow. I'm the Business Development Manager at Paycheck. And this is the second of the series of our webinars at the moment. So some of you may have joined the previous one before, and we also hosted a live question and answer session a couple of weeks ago regarding furlough. So some of you may have already been on these webinar sessions prior. So thank you so much for joining again if you have. I am joined this morning by our partners Croner HR. Both Monica and Martin are here this morning and are going to run you through the presentation. So I'm going to hand over to Martin now. He's going to give you a brief overview about himself and Croner and Monica also.
Hi, good morning everyone. My name's Martin Vodden. I'm Business Development Manager for Croner primarily in London and the South East, but I do cover nationwide. I know the majority of people joining this webinar are London based. Just a brief bit of background about Croner. So we've been running since 1941, so soon approaching 79 years in our industry. As a primary function, we do outsourced HR support and employment law advice. Managing small to medium businesses HR function right the way from employment contracts through to employment tribunals. We handle approximately 270,000 advice line calls every year and approaching 10,000 clients across the UK. Joining me as well this morning is my colleague Monica Price. So Monica is our guest speaker. She's a wellbeing expert and health and safety, and is a TV and radio presenter. So I'll hand back to Misha, and Misha will run you through the agenda and then pass over to Monica.
Yeah, perfect, thank you. So the agenda for today's session, Monica is going to run you through employment law and any HR documentation. We'll also be touching on the topic of conversation at the moment, which is everything surrounding COVID-19 and furloughing staff. Any employment tribunals, as Martin said, employee wellbeing, and there will be an opportunity for a question and answer session. There will be a lot of conversation surrounding coronavirus and the situation at the moment, and I know that there will be points being made as to what, from an employer's perspective, what you guys should be doing. So please keep those questions coming through. The question box is on the right hand side of your screen. You should see it there. So any questions that you have throughout the session today, please put them through there. We will have the opportunity to run through them. There are a lot of you on the session this morning, so if for whatever reason we're unable to get through them all, we will be able to follow up with you, but yeah, please keep them coming as and when, and we will do our best to answer as many as possible. So I'm going to hand over to Monica now, who's going to run you through the presentation for this morning.
Thank you, Misha. Good morning, everybody. My name is Monica Price, and as Misha said, I'm here with my colleague Martin today. It's my pleasure to be with you this morning. So let's take us through then what we're going to be looking at today. So employment law, let's start off with employment law and HR documentation. So all employees must have an employment contract. Well, I'm sure you're aware of that, but of course, because of COVID-19 and because of the global pandemic crisis that we're going through, particularly in the UK, we seem to have forgotten the Good Work Plan, which came into effect on the 6th of April this year. So start from the 6th of April this year, contracts change. So normally you would have a contract that you'd have 8 weeks to issue that contract. Well, from the 6th of April, it became from day one. So we're going to look at that in a bit more detail as we go through. Both the employee and the employer, of course, must stick to this contract throughout the duration of employment. Right, so there's three main parts of an employment contract. So you've got your statutory, explicit and implied. So the statutory would be exactly what you expect, or your statutory requirements. Often when Martin goes out and visits clients, and of course we're doing video at the moment, not so much of the visiting, but you know, we're looking at contracts because this is something, policies, procedures and contracts are vital at the moment, and it's really important that yours are totally up to date. So there's three parts to it. So the statutory, as I've said, these are statutory requirements. The explicit would be more about the job description, the hours, obviously the name, the address, or anything explicit to that particular role. And of course, the implied would be things like you expect them to behave in a professional manner at all times. You expect them to adhere to your company's policies and procedures at all times. So there's often we don't see those three main components of a contract, and they are really, really important to ensure that you've got a robust enough contract to ensure that just in case further on down the line there's no retribution and somebody tries to take you to court for whatever reason, your contract is your main point of starting point, really, and it needs to be robust enough to make sure that you don't have any problems in the future. So what should you provide? Well, a written statement of employment particulars and an employee handbook. So the written statement is the SMTs. So that's your legal requirement. You have to provide that to your employees. And again, this is a really important document. It's really important that you have everything in there that pertains really to that particular role. But some people, often what we find is some people put too many things in the contract and which really should be in the handbook, and likewise things in the handbook that should be in the contract. It's worth reminding you that, because it's a legal requirement, anything you're putting in the contract, you are legally bound to. Now, as far as the employee handbook is concerned, whilst not a legal requirement, it's a best practice. And particularly, again, as we're going through this COVID-19 crisis, this is something you should be referring your employees to. Some of you may have already furloughed staff. Some of you may already be thinking about furloughing your staff. Some of you have got all your employees working at home now. So your handbook is their first port of call to ensure that they know exactly what your expectations are as a business. So as far as the written statement's concerned, so do you know when you have to provide this written statement? So your statement of main terms. Well, as I said, it's from day one. Originally, it was before the 6th of April, it was you had 8 weeks to provide this statement, but now you have to provide it on the first day of employment, and the wider written statement within 2 months of the start of employment. And what sort of things should this contain? Well, as I say, it's the employer's name, it's the job title, description of work, their start date, of course, how much and how often an employee will get paid, so their hours, their days of work, again, everything, all the information that's required of you as an employer should be given to the employee. Obviously, holiday entitlement, how long this job is expected to last if you're on a short-term contract. So all these things need to be written in this statement. And any additional information, well, again, it totally depends on your business. It could be that, you expect them to work away from home for a certain amount of times, or perhaps work even in another country, or you expect them to have a company car, or, use your computer, use your phone, all these things that pertain to that particular role. This is the time to make sure that you get it right. So if you've got any kind of queries, or you're unsure about what or should go in, then please, speak to Martin, because we'll be able to help you. So as far as policies and procedures are concerned, well, as well as a written statement, you should also provide employees with all of your employment rules and policies. And we ask ourselves this question, why is this important? Now, if you were with me today and we were in a seminar and I could see you all, we'd probably have lots of answers in the room. But, the main point of showing your employees your policies and procedures is it shows your expectations. It kind of lays out your rules and your regulations, your expectations of what is expected of your employees. If you don't provide your employees with a handbook, then they have nowhere to go. So there's no recourse. You can't say pull somebody in who's perhaps on a disciplinary or has done something wrong if they have no policies and procedures to use as their guideline. So it's vital. Whilst it's not, as I say, the handbook is not a legal requirement, the courts would wonder why you haven't got a handbook in place. So if you're perhaps one of the employers who haven't got a handbook in place, don't worry, these things can be done. And of course, particularly because we're going through this crisis, it's, as I say, it's really important that we have these up to date. So if you haven't looked at your policies and procedures much before now, because you've been focusing on other things, to be fair, now's the time to get them out and make sure that they're totally up to date as they possibly can be. So let's look at all the policies. So we'll put them all up here. You know, we've got loads. There's loads of policies that you could have, and I think we've got a couple of pages of these. You know, the things obviously that we're talking about today, which would be important because of COVID-19, would of course be a COVID-19 policy. So do you have a coronavirus policy, for example? So again, we're getting lots of people call our advice lines about guidance on that. So, you know, please make sure, again, speak to Martin, because we can help you with that. Another important policy would be, of course, a working at home policy. If you have employees working at home for you currently, you need to ensure that you have a policy in place. And again, it might not have been something you've had in place before now. So don't worry, you can put all these policies in place. And of course, something like a working from home policy is really important. Both of those two policies are quite important at the moment. So with your working at home policy, for example, you know, have you conducted a risk assessment? Just make sure that the person working at home is working in a safe space. You know, are you expecting your employee to sit at a dining room table on a dining room chair all day at a computer whilst not having something that's comfortable and suitable for purpose? Also, internet could be a problem. You know, have you perhaps got to pay a little bit extra to ensure that they have a full, you know, a band service so that you can actually carry on with their duties? All these things will be, that's why risk assessment is so good, because it allows you then to identify, are there any risks with this person working at home, and what can I do to help them? Also, another one at the moment, of course, is looking at confidentiality. You know, confidentiality is really important, of course, in any business. Training is another one, because, you know, even especially if you've got perhaps your employees are on furlough, they're not allowed to work for you, but they can be doing some online training. So again, does your policy reflect that? You know, other important ones that would have been important before all of this, you know, don't seem so important now. But, you know, it might be worth just taking a look at your social media policies, because ask yourself, what are you allowing your employees to post during this virus? You know, you might not want lots of information going up about it. You may not have a problem with it whatsoever. Again, it's your business, your policy. So it's ensuring that you're making sure that you're controlling your business, especially if you've got people working remotely or working from home. So again, all of these policies have a place. It's about identifying them. So telling yourself now, right, we'll have a look at our policies and procedures, get them all out, and just make sure they're as up to date as we possibly can. So the employee handbook, as I said, not a legal requirement, but absolutely best practice. So do you have a handbook? These are the questions you need to ask yourself. And again, moving forward, as we come through this crisis, which we will come through this, albeit we don't know what time and how long yet, but we are going to get through this. So again, it's about having your handbook, making sure that you reflect this. So where do you keep it, for instance? You know, can the staff access it? And how often have you updated it? You know, make sure that it hasn't just been put on a shelf and it's been, you know, it's just been left and forgotten. Don't forget that when your employee signs to say that they've read and understood your handbook, that's exactly what they're doing. They're signing to say they've agreed, read and understood the handbook. So at any time you can make changes and obviously add and alter that handbook to suit your purpose. Again, let your staff know. Again, you don't have to, but if it's a major change and you're adding a policy, then of course you would share it with your staff. The key thing at the moment is communication with your staff. You know, these are very anxious times for all of your staff, regarding whether you're a key worker, you know, whether you're coming to work, whether you're working from home. These are very anxious times. So it's important that you're giving as much information to your staff as you possibly can. So let's talk about furlough. Obviously, the job retention scheme, we're probably well aware of it now. All businesses are aware that this portal opened on the 20th of April, so it's just opened. You know, in the first few days, we had over 450,000 people access the furlough system. And again, touch wood, we've had no bad reports of it crashing or failing. In fact, it's doing a very good job. So if you have or are considering furlough, I think the thing to remember is we probably haven't even heard of the word furlough before now, because it's not a word we've often seen in UK law. It's more US law. But the furlough means a leave of absence. So what you're doing, the whole point of the job retention retention scheme was to do just that, to put your staff on a temporary leave of absence, paid 80%, but it's in order for you to bring them back when we're through this crisis. So again, if you're considering this, or you're thinking about doing this, or you've actually done it, obviously you'll be aware that the criteria from the government is it's a grant-based system, and they do pay 80% of the wage or salary. And of course, there's criteria to be met. It is completely separate, though, to layoff or a shortage of work. So as I've said, furlough in its original sense means no work, no pay. But the scheme overrides that no pay element and requires employers to pay the 80% to employees. Now, what's happening and what we're seeing is some employers are actually topping up with that extra 20% to make sure that their employees are getting their 100% wage. Again, there's no legal requirement for you to do that, but again, it might be something you want to consider. So what happens on furlough? Well, if employees want to take on a new job whilst they're on furlough, then you should revert to your normal rules on this. You may have contractual requirement for your employees to notify you, for example, of your intention to get another job. And again, it's worth noting that whilst that person is on furlough, they're still getting that 80% pay, which is a grant from the government. And it is backdated. It's backdated from the 1st of March. And we now know, of course, that the scheme is open now to the end of June. Again, the government have the right to prolong that again, to extend that. But currently, we're being updated on a day, almost a daily basis. So this is really something you need to keep your eye on. But as far as furlough staff is concerned, they cannot work for you. And don't forget, even if you have a staff member at home on furlough, and perhaps you've got a customer service query, or perhaps you want them to do some social media for you, that could still be deemed as work. So the idea is they don't work at all, but they can get another job. So as long as there's no conflict of interest, and the new job is outside of normal working hours, that will be fine. So if you've got that, as you can see, we've got, for instance, Flybe pilots are now working as distributors for Tesco's. So this is perfectly legal to do whilst they're on furlough. But the most important thing is for you to have in place very robust systems to ensure that when they do come back, when you do bring them back to work, then they're coming back to work for you. So there can be no conflict of interest. So again, if you need any help on that, Martin can extend on that for you. If an employer chooses to place the employee on furlough, that employee will remain on furlough for a minimum of 3 weeks. That is the minimum requirement you can put an employee onto furlough. And again, at the moment, currently it's running to the end of June. And what's happening is, and what we're finding is, people are doing that. They're putting them on furlough for say 3 weeks or 4 weeks. And at the end of that period, then they're putting them on furlough again. And again, that's perfectly fine for you to do that. You can keep putting them on furlough as long as the scheme is open. So how do you evoke it? So again, discussions need to be held. You can't just say to your employees, right, I'm putting you all on furlough. You need to think, first of all, as an employer, think about the people that you would like to put on furlough. So of course, perhaps non-essential staff would be the first port of call. You need to agree it with your employees. So you need to talk to them, you need to communicate with them, and you need to let them know the reasons why you're doing it. Once they've agreed, an employer must write to the employee confirming that they have been furloughed, including the start date of the furlough, and that is all for the eligibility for, to make sure they can claim. And of course, this record must be kept for 5 years. So this is all about making sure that you've got everything in order and you've kept records so that you're safe once we come through this. So if there's any more questions on furlough before we go on to tribunal statistics, please do, please do ask Martin at the end of this webinar, or indeed, if you've got any other questions that you're just unsure of. But what we do know is that it's a continual process. So people are furloughing still. Just because it's opened on the 20th, people might not have decided to furlough staff yet, but they can still furlough staff. So again, any further questions, just point them to Martin and we'll be able to help you. So let's look at tribunal statistics. So unfair dismissal, there was 21,000 claims, Underpayment of wages, 22,000 claims. Holiday entitlement, 49,000 claims. Sex disability discrimination, 16,000 claims. And equal pay, 27,000 claims. So again, this is just to give you some stats, because what you don't want to do, and why it's so important for you to have your policies and procedures and contracts in order, is to have any kind of tribunal once we come out of this. And we're already seeing businesses that are just demanding staff just to come into work, demanding that their staff go on to furlough. You know, there has to be discussions. There's a protocol to follow, and you have to do it correctly. So as far as unfair dismissal is concerned, you know, to be considered fair, the main reason for a dismissal must fall into one of the following categories. So if you're thinking about perhaps furloughing some staff, or you're thinking about redundancy or dismissing, you know, you have to be aware that there is a code of conduct to follow. So capability. Now, we often say capability is used as a last resort. So you have to have shown that you've done everything you can to ensure that person isn't capable of carrying out that role, that they've been contractually obligated to do so. So capability is one to use if that doesn't fall under that category. Conduct, of course, your code of conduct, that'll be in your policies and procedures, is ensuring that they act at all times in the best interest of your company. Redundancy, you know, again, you may already be considering redundancies, or indeed having already started the redundancy process. So again, it's something to think about. And a legal restriction, again, there could be some other reason why that person perhaps has to be dismissed. Perhaps their work permit has you know, lapsed. Any other reason that is what we call some other substantial reason, but there has to be just that. It has to be a substantial reason, and employers must act reasonably in carrying out the dismissal, which includes conducting a fair procedure. So you can't just get rid of people. There has to be a procedure that you have to follow. So common mistakes that people make, and again, when Martin goes out to see businesses, these are some of the things that they do make. So the employers should be mindful of the following: the 2-year problem. So the long service is not required for claims of automatic unfair dismissal. Rushing a dismissal without carrying out a full investigation and disciplinary process, and failing to allow the employee an opportunity to appeal against their dismissal. So it's worth noting those 3 points are really, really important, because if you don't, then if you make any one of these mistakes, then the chances are that you are going to be landed with something like a tribunal suit, and we don't want that. The idea is that we're trying not to you know, let you be in court. You know, we can't always guarantee that, but the idea is that you put processes and policies and systems in place to ensure if you are taken to court, then the courts will look at your side rather than fare somebody that's trying to claim against you. So underpayment of wages, again, this is something that, you know, employers sometimes do. It's something that, you know, we come across, but workers are protected from having unlawful deductions made from their wages. In other words, you can't just take payments out of their wages. So generally, wage deductions can only be done with the employee's agreement. Underpayment of holiday pay, for instance, is often classed as an underpayment of wages. And again, in these times where, you know, these are very, very unprecedented times, so we're doing lots of things first. You know, this is a first for many, you know, first for policies, first for procedures, actions that we're taking. Businesses are changing, businesses are having to redirect their business, but you know, you can't start taking wages from your employees. Different holiday pay calculations exist for those who work irregular hours, for instance, for example, those on 0-hour contracts. So employers should be mindful of these as well. Staff should be paid their normal weekly pay for a week's annual leave. Wage deductions for conduct, for example, wastage or damage to property, should be outlined in the contract of employment and reflect the loss sustained by the employer. Excuse me, holiday pay. The 12-week average principle applies here when calculating holiday pay for staff working irregular hours. And overtime and commission payments will also have to be included in holiday pay in specific circumstances. So again, if you're unsure about any of that, please do ask any questions. So just to summarise on this section, the claims for unfair dismissal, holiday entitlements, underpayment of wages, discrimination and equal pay continue to be commonplace at employment tribunals. As I say, when Martin goes out to businesses, these are the things that he sees all the time. So a lack of understanding is often key to the mismanagement of these situations. It's about making sure that you know exactly what the procedure should be. And employers should ensure that they are up to date on the latest workplace requirements. Again, if you were part of Croner, we give you regular updated information to ensure that you are up to date. Accurate and reliable policies can help form a framework of good business practice. Absolutely. Your policies and procedures and your contracts, as I've said, are absolutely vital and key to a successful business. So let's look at your duty of care now. So your duty of care, obviously under the Health and Safety at Work Act, is that you have a duty of care under that act towards your employees, which includes not exposing them to unnecessary risk. So for example, if you've got workers now, perhaps you're one of the key workers, or indeed you've just decided to come back to work or are thinking about coming back to work, then you need to make sure that you're not putting them in a position in which they could become infected with COVID-19. So you've got to take what we call reasonable precautions. So social distancing, of course, PPE, personal protective equipment. You as an employer have a responsibility to provide those. So again, conduct a risk assessment. It's a brilliant tool that enables you to look at the risks, the hazards, and the fact that then you can work out what you need to do to ensure that everyone's safe. Wellbeing as well, often kind of left behind, but you have a legal obligation and a duty of care. So you have to take care of the welfare of your employees. Now, particularly as we're going through this, you're going to have mental health is going to be huge when we come out of this. It was already growing. Mental health issues were already growing before we even had COVID-19, but we've now got people who are very anxious, very scared of their future. Perhaps they have financial worries and difficulties, and all of these things are going to affect their health and well-being. So perhaps remind employees of any wellbeing initiative you have at the moment. So if you've got any initiatives that you've had in the past, now's the time to kind of reissue them and let your employees know about them. And sometimes simply signposting can be really efficient as well. So just signposting them to organisations, to charities, or to local businesses that might be able to help them. But you need to have, so of course, mental health and wellbeing policy is a key policy for you to have at this present moment. So frequently asked questions, we've got a couple of quick questions here we'll go through that we've been frequently asked. So do I have to pay someone with the coronavirus? So if an employee is legitimately sick with the virus, then they may qualify for at least statutory sick pay if they meet the eligibility requirements. If their contract states they're provided more, then they will receive that. The statutory sick pay is paid at 95 to 85 pence a week, but up to 28 weeks. And now, because of the COVID-19, the government's changed that now from the first day of the sickness absenteeism, if though their first day of absence was on or after the 13th of March from this year. And again, you've got to be flexible with your requirement for a doctor's note or to visit a doctor, because of course we're being asked to stay away from doctors. Doctors' surgeries are doing lots of video calls, so this may be something that you're going to have to be a little bit flexible and just wait for. And then the other question we're commonly being asked is, can we continue with our day-to-day business operations so long as we observe social distancing rules and other government guidelines? Well, technically, yes, you can, even if your business is not considered essential. However, the point to remember is that as a result of the UK lockdown, only essential travel is permitted. So the police are out on all of the main motorways across the UK, and they will stop you and they will ask you what you're doing on the roads. So the government advised that everyone who can work from home should work from home. During furlough, of course, an employee cannot do any work, as I've said, for their employer apart from training. So online training is the only thing that they're allowed to do, and of course, which does not provide services to the employer or is making money for them. So those are two common questions that we're being asked currently. And now that brings me to the end of my presentation here, and I do hope that you found it useful and that you've taken some things away from it. Obviously, we've got now an opportunity for a Q&A session with Martin. So Misha and Martin, I'll hand back to you.
Thank you, Monica. Okay, so yeah, I hope that that has actually generated a lot of questions for you guys, because now's the perfect opportunity to ask the experts the questions that have been burning on your mind, really. So I'm going to run through them now. Martin's going to answer them. So Martin, first question: we have successfully made our first furlough claim and got paid by HMRC. Will next month be the same process?
Okay, so very straightforward. The next month will be the same process in terms of submitting the claim through the HMRC portal. With regards to what you need in order to comply with that, post all these claims, because HMRC have said that all documentation related to furlough needs to be kept by employers for 5 years. So that includes the letter that's gone from the employer with regards to them being furloughed and their agreement to be furloughed, and the changes to the terms and conditions of employment, which are their employment contracts related to furlough, because with furlough being a very new term in the UK, up until about 5 weeks ago, nobody had ever heard of it. So unless you had a very American contract, it was highly unlikely that you'd have furlough in that contract. Therefore, you must update employment contracts to reflect furlough and the fact that you are using, obviously, the job retention scheme to make those claims. So that's part of where our documentation comes in as well.
Perfect, thank you. Next question: can you insist that staff continue working full-time but take a 20% reduction in salary currently, even if all staff do not agree?
Okay, so there's probably two parts to this. One, if they are on furlough, as Monica said through the presentation, they can't be working for you. And providing they agree, you can pay them 80% and then claim that money back from the job retention scheme. However, if you are keeping them in work and keeping them in the business, but asking them to take a 20% pay cut, which a number of companies have done, then there has to be an option via either the handbook or the contract, which is known as a shortage of work policy. Shortage of work policy enables you to have a negotiation with the employee about reducing hours or money, pending agreement again from the employee. The key to most of this is making sure that your employment documentation is up to date. Obviously, following this webinar, I'll send everyone that's attended an email with regards to employment law documentation, but it's really important that it's updated and you have things like that in there. Otherwise, it could lead to a breach of contract claim.
Great. Do you have to get employees to sign a handbook receipt upon you issuing a new updated one?
Okay, so handbooks, as we know, if they're being done properly, can be updated as often as, well, currently probably every other day, but in general 2 to 3 times a year, usually when there's a budget in April and October. Now, that depends on the documentation you had in place when you first originally rolled out an employee handbook. So if your employee handbook had came with a piece of paper that said that I've read and understood my employee handbook and that you're allowed to make changes whenever you'd like to, then no, you don't have to get them to re-sign it every time. However, if that document just simply says I've read and understood my employee handbook with no ability to make changes when you want to, then yes, you'd have to get them to re-sign every time.
And if you already have a signed receipt every year, once you update it, do you need another?
Depending on what's, going back to the answer for the last one, just depends on what's in the signed receipt from the previous year. So if the signed receipt from the previous year says that you will make changes from time to time as you need to, then no, you won't need to have that re-signed every year.
Okay. If someone accepts to be furloughed, does this make this more likely that you will be made redundant rather than not agreeing to it? And what happens if an employee does not agree to be furloughed?
That's a tough question. Okay, so if somebody is accepting to be furloughed, I think that depends on the business they're working for. No, I don't think it makes them more likely to be made redundant. If anything, they're showing their support in helping the business sustain themselves and allowing to use the job retention scheme to keep paying their employees through what is a really difficult and challenging period. Redundancy will come from businesses and as employers and employees, I think what's happened recently in terms of furloughing and everything has been probably, and we don't know this yet, but probably the most simple part of this, because as yet we don't know how we're going to be released back into the world, and we don't know how business will be once we come out the other side of this. So I don't think being furloughed, whether you've accepted it or not accepted it, will have a bearing on whether there's redundancies or not.
Okay. Please, can you provide context to the tribunal numbers? Were they in a year, week, month, and what percentage of total employees?
Percentage of total employees, I'm not sure. Those figures were in a year, and they're increasing every year. In around 4 years ago now, the fees for tribunals were removed, so that's led to an increase. So I speak to different customers every day. I've spoken to 2 this week that have started the road of a tribunal, one of their ex-employees, and those figures are increasing all the time, purely on the basis that it doesn't cost the ex-employee now anything to take a company to a tribunal, and claims are becoming more frivolous and more often and for different reasons. So those figures were over the course of a year, but they do increase year on year every year at the moment.
Perfect, thank you. Have you heard if the government are changing the furlough rules and reducing the minimum term to less than 3 weeks? We have 2 staff at the same level doing the same job with similar personal situations, and if we need to furlough, we would rather furlough them for alternate weeks rather than choosing one or the other. Good question.
Okay, all right, that's a good question. So that depends on what's in the documentation, again, around the agreement in the furlough letter, and also it depends on the documentation in terms of the employees themselves. So the furlough is for a minimum of 3 weeks the first time you do it. So this question came up with a client that I was talking to yesterday, and they wanted to know if they had to then furlough again for another 3 weeks, or whether they could potentially bring them back, say, after 3 weeks and 4 days. If they have been furloughed for a minimum of 3 weeks, then the following periods of furlough don't have to be for 3 weeks at a time. So yes, in theory, you could then start to rotate, providing the documentation is where it needs to be, and that's something that I'll go into on the follow-up email as well.
Thank you. Do I have to make my staff take holiday while they are working from home, or are they allowed to take it when we are out of lockdown?
So it's going to vary business to business. So I'll give you this is internal for Croner in terms of how we've done it. If you already had holiday booked, you can't cancel it just because you're working from home. It comes down to each individual business's holiday policy. So if your normal holiday policy was that somebody could cancel any holiday booked if they gave a minimum of 2 weeks notice, then you still have to live by that, even though they're working from home, and in theory, they probably won't be going on holiday. Employees, you can't force holiday on them unless it is agreed already in their contracts or handbooks. So a lot of companies will do that over the Christmas period, for example, when business is shut down. So you can still maintain doing that. You can't force employees to take holiday, and the government has already said that whereas normally a lot of companies, again, in their policies will have that you can't roll over holiday year to year, there is going to be the ability to do that for the next 2 years in order to help get the economy moving again when we come out of this. So there is a high chance that a number of employees will be carrying over holiday into next year and the year after.
When an employee is brought back from furlough, is there a minimum requirement for how long they must remain employed?
No, is a short answer to that. I've had so look, it's a difficult world out there at the moment. So we've had various different queries and questions over the last few weeks from clients that have joined us, and there's been businesses that know they won't be able to sustain the same number of staff when they come out the other side of this. And whilst an employee is furloughed, that doesn't protect them from normal business processes. And coming out the other side, if a business needs to make changes to be able to survive and provide work and provide jobs and keep the business going itself, it can still make those changes, providing they follow what's in their documentation, because otherwise that will lead to obviously potential claims.
What kind of points should be covered in the COVID-19 policy?
That is changing all the time. So that's something that we would write for employers as part of their handbooks. It's related to potential health and safety, how the employee's responsibility in terms of when they let their employer know. Let's assume the business is still running, because there are a number of businesses, including key workers, that are still running. When and how they should advise their employer about the fact they're self-isolating or someone in their household has symptoms, what the employer's responsibility is to the employee with regards to, and it is changing every 2 to 3 days. So that's something that we're updating as we go.
Okay. Can furloughed workers who are not working for you work somewhere else?
If you have them on furlough, they can't do any work that directly benefits your business or any work directly for you. And there is a really grey area about working within technically the same industry, so in competition effectively with you, because again, that will probably breach their restricted covenants and confidentiality in their contract. However, if somebody is working for, say, an office stationery business that is currently not operating, and they are being furloughed at 80% of their salary, and they choose to go and work full time in Tesco's where we need people out there working, then yes, they absolutely can.
Great. If we take staff off of furlough, do we have to confirm this in writing, and do we have to specify the period they will be off of furlough?
Not for the length of the period, because things can change very quickly. You can unfurlough, as we said, after the first initial period of 3 weeks, and then after that it's fairly flexible depending on what's in your policies and your contracts and your handbooks. In terms of from a policy and procedure perspective, you don't have to keep them on furlough. You can bring them off furlough and you can put them back on when you need to.
Okay. I have an employee who has not yet got a national insurance number. She's also not yet able to apply for one due to COVID-19. I was not able to claim from HMRC because of her not having a national insurance number. What do I do about it?
If you can't claim, so there is the potential for short-term layoff. Again, that needs to be in a contract or a handbook. That's the kind of thing we can help introduce and help you through. So short-term layoff enables you to retain them as an employee whilst paying them a very nominal amount for the first week that they're laid off, and then nothing until they're brought back for a maximum of 6 weeks out of the next 13. And then there is the potential of redundancies or agreeing a period of unpaid leave if you can't claim back and the business can't afford to pay the salary.
Okay. I'm not sure if you'll be able to answer this or if this is more a payroll question, but if overtime is only done if the employee wants to do it, should it be included when paying holiday? Also, should any enhanced payments for doing certain types of work be included?
This at the moment is fairly recent and is developing, and there will be, I'm sure, precedent tribunal claims related to it. So in terms of bonuses and commission helping towards or helping to calculate holiday pay and everything else, if the rule is at the moment, if it is regular, contractual, non-discretionary, and something that happens very, very often, then yes, it should be calculated and included. In terms of overtime, yes, that does accrue holiday, providing it's paid as overtime. Obviously, most of us that are salaried will have in our contracts that we have. Occasionally, we might be asked to do something outside of our contract. If somebody is hourly paid and they're working more hours than is in their contract, then yes, that will accrue holiday.
Perfect, thank you. At the end of furlough, when our business reopens, we may be quieter than before coronavirus. Can we let some staff go or make them redundant?
That's something that when I send the email about, so part of the email that I'll send will be offering one-to-one consultations to go through more individual needs for particular businesses. And I'll set out some times in that email where I'm available to do that. So this kind of question is coming up now more than actually furlough when we're speaking to clients, because people are starting to look at what happens when the government switches off the furlough scheme. And ultimately, if the business is not as busy, so I'll give you a great example, hairdressers. Hairdressers will be really busy when we come out the other side of this, but there is going to be social distancing restrictions in place in those hairdressers. Therefore, it might be that they can only have 2 hairdressers working at the same time, with people queuing 2 meters apart, potentially out the door. Some of those hairdressers, and I spoke to one yesterday, have 5 or 6 hairdressers that work for them. So it's a case of either reducing hours and rotating staff, or unfortunately for temporarily having to let some of the staff members go. Yes, you can, providing again the documentation is correct in terms of redundancy, layoff, and other things that you may use.
I think the same person who asked previously has just asked again, what happens if an employee doesn't agree to be furloughed?
So if an employee doesn't agree to be furloughed and the business can't sustain the salary and the business doesn't have work for them. So there is a key thing here. If the business has work for them, then they shouldn't be furloughing anybody. If the business doesn't have work and the employee doesn't agree to be furloughed, then it would be a case that it's up to the business, providing their documentation is correct, if they wanted to go down the route of redundancy or laying off. Businesses are in a bit of a tricky position in what they can and can't do at the moment.
Okay, this is quite a long question. So regarding holidays for those staff furloughed, we are topping up the salary to 100%. However, they are all going to come back with accrued holiday pay, including bank holidays. Given that those staff who are still working are being requested to continue to take annual leave due to ramping up of business when this is over, it's creating a bit of them and us culture. Could we ask them to donate their bank holidays back to the charity, or will this be a breach of contract? They are contracted to 27 days plus bank holidays, so more than statutory. I know that the government have now confirmed that we can ask furloughed staff to take holidays, but there is no incentive given that we are topping them up to 100% pay. Any suggestions?
Had this query a few times because obviously employers are trying to make sure that we come out of this with a fairly balanced amount of holiday left for the year, which is why the government's opened it up to be able to be carried over for the next 2 years. Unfortunately, if an employee doesn't agree and they're contracted to 27 days plus bank holidays, you can't force them to reduce that or donate it back. We can try, and if you obviously again, when I send the follow-up email, if you come back to me, we can try and help you put something together that tries to negotiate with the employees to do such a thing, but anything like that has to be done with agreement in writing.
Okay, perfect. Just had a couple of people ask you to just clarify the answer about the flexibility after an employee has completed the initial 3 weeks of furlough. So I think about not having to do it for another 3 weeks. So someone said, can I unfurlough for a day and then refurlough for less than 3 further weeks?
Again, documentation, contracts, handbooks have to be updated prior to this because, and also, or even with employee agreement as you go along, with then an update done to the employment contracts and handbooks. I think if there's specific questions about types of businesses, number of days, yes, there is potential, but the best thing to do individually is to speak to the person asking that question related to what their business is. But there is potential to do that, yes, depending on what's in the contracts and handbooks and the employee agreement as well.
Okay, perfect. There are a few questions that we'll need to come back on because they're a bit more personal. Are there any questions on here, Martin, that you think I've missed that you want to cover now?
I'm just having a scroll through now. We've done the national insurance for number 1.
Yeah. Yeah, I think, I think the others we might need to follow up on after the session. Do you agree?
Yeah.
Okay.
There is one about adding, sorry, I will just pick up on one that I've just seen come through. So there's a question that says to add a furlough policy to contracts, brackets for future, not current situation. How does that differ from leave of absence or sabbatical? I'll just pick up on that. So furlough is very different. Furlough is related to job retention scheme currently in the UK, because furlough is not something that's used in the UK, well, very often, if at all. Sabbatical is not the same as furlough because sabbatical is an agreed extended break taken between employer and employee that's agreed beforehand with an open-ended return date. Whereas furlough is obviously set periods of time.
Okay. Oh, someone else has just asked, are bank holidays paid at full or 80% of furlough?
Bank holidays and holiday are paid in full.
Okay, and can furloughed workers who are not working for you work somewhere else? I think that question's already been answered a few times.
Yeah, I think we've answered that one. Yes, they can, providing it doesn't conflict with your existing business or benefit your business. So, for example, you are a charity and something they're doing and being paid to do somewhere else is directly benefiting your charity. That's also not allowed.
Okay, perfect.
We've covered most of them.
Yeah, I think. I think the others are personal. So what I'll say is, we'll end the questions for now. I'm sorry, I'm just checking because there are still some coming through. If there are any that we can answer. Yeah, I think. Do you want to follow up on those ones, Martin, that are coming through now?
Yeah, I'll follow up on those because some of those are pretty individual to set businesses.
Yeah. Okay. So basically we'll send a copy of this webinar out. It's been recorded, so you will get a follow-up of that. I think it'll probably be tomorrow that you'll be able to refer back to it. So it will just be a recording of this. My details are on screen, but so are Martin's. So if you have any questions or anything that you would like to follow up on off the back of this, you're more than welcome to send them to me. However, Martin is probably your go-to for the answer of these questions. I really appreciate your time in joining the session today. I know that there've been a lot of questions, and even though this has been going on for a good few weeks now, it's still very uncertain, and I know that businesses are still unsure about what they should and shouldn't be doing. So hopefully this webinar has answered a lot of the questions that you guys did have. The questions that are still coming through now, we will be able to run a report off of those, so we can follow up on them after today, and Martin can get in touch with you and have a conversation with you, a video call if necessary. Martin, is there anything else that you would like to say?
No, I appreciate everybody attending this morning, and as I say, I'll send a follow-up email this afternoon to those of you with questions and to the people that came, just to say thank you, and sometimes if anybody does want to do one-to-one consultations to go through anything specific.
Perfect. Thank you so much for dialing in, everyone. I hope you all have a good of a day as possible. Keep safe, stay at home, and hopefully we'll see you all soon. Take care, everyone. Bye bye.